You're standing on a sidewalk in California and an officer says, "Hand me your phone." And maybe you're at a traffic stop. Maybe they're investigating something and your phone is suddenly the focus for whatever reason. If you're wondering whether police can search your phone in California, the answer is almost always no. Not without the right legal process. But what you say in that moment matters enormously because people give consent every day without realizing it. I'm Nana Knight, I'm criminal defense attorney in San Jose, California, and in this video, I will give you the exact words to use when police ask for your phone and what to do if they demand you unlock it, and what to do if they take it anyway. Your phone is not just a phone. It's your location history, your messages, your photos, your banking apps, your search history, your social media accounts, and your entire private life. Confidential and private text communications that you've had with your friends and family. And that is why in most situations, police need a warrant to search the contents of a phone. The United States Supreme Court made this very clear in the case of Riley versus California, a case that came out in 2014. And this decision specifically held that police generally cannot search the digital contents of a cell phone without a warrant, even when the phone is seized incident to a lawful arrest. California adds its own layer on top of that. The California Electronic Communications Privacy Act, known as CalECPA, generally requires law enforcement to obtain a warrant before accessing the contents of electronic devices, including phones. Also, actually, your social media content as well from the providers. It also requires that they notify you that they have obtained your records. So notice to the consumer is required. It is one of the stronger digital privacy laws in the country, and it applies right here in California and Bay Area specifically. But here's the trap that catches people every time. The fastest way around a warrant requirement is consent. If you hand over the phone, if you scroll it to show something to the police, or if you unlock it when you're asked, you have just waived your rights and given them the consent to search without any legal process. So let's talk about what to say. The one sentence that protects you is, "I do not consent to a search of my phone." Say it clearly, say it once, then stop adding to it. If they follow up with, "You have nothing to hide, so let's just take a quick look," your response is going to be, "I understand, I still do not consent," if you want to invoke your privacy rights. If they say, "Just unlock it for a second," you can say, "I'm not going to unlock my phone. I want to speak with my lawyer first." Let me walk you through the most common scenarios you will actually face. Scenario number 1, the casual ask at a traffic stop. "Can I take a look at your phone?" This sounds informal. It's not. The answer is, "No, I do not consent to the search of my phone." Scenario number 2, "Give me your phone." If you're not detained, you can ask, "Am I being detained? Am I under arrest?" If the answer is no, you can say, "I'm going to keep my property. I do not consent to the search of my phone." If you're detained or under arrest, police may seize property. You shouldn't be fighting or resisting the collection of your property. If you're being arrested, do not physically resist. Do not grab it back. Do not argue or fight with the police, and do not escalate things, okay? Instead, you can clearly say, "I'm not resisting. I do not consent to any search of my phone." That sentence on the record matters later when your attorney files a potential suppression motion. Scenario number 3, unlock it. People panic here because they assume refusing is illegal and they have to absolutely submit to the officer's demand and comply, or that it makes them look guilty if they don't. It doesn't. In California, the safest position is to decline to unlock your phone voluntarily and to decline to provide your passcode. You can say, "I do not consent. I will not unlock my phone. I want my attorney." If they keep pressing, repeat the same sentence. Do not get drawn into a debate or an argument or a fight with the police about your rights on the side of the road. You're not going to win that argument in the moment, and every extra word you say creates new risk. Scenario number 4, we will get a warrant. Let them. Your response is going to be, "Okay, if you get a warrant, my lawyer can review it. I do not consent to a search." Then stop talking. Whether they can actually get a warrant is their problem to solve, not yours to help with. Scenario number 5, just show me the text chain with her. We want to see what you communicated with the other party. This comes up in domestic violence situations and relationship disputes constantly. Police think showing them the thread will clear it up, but it will not. You may expose other messages you never intended to share, and once they see something, they may claim that plain view as a basis to go further, right? So you can say, I'm not showing you my phone. I do not consent to a search of my phone. But what if the police take your phone even without consent or a warrant? You need to stay calm. Do not physically resist. After the encounter, do the following as soon as possible. First, write down everything you remember. Which officer took it, if you remember, what time, what they said before and after, and whether you heard them say they had a warrant. Then contact an attorney immediately. If your phone was seized without a warrant and without consent, an attorney can file a motion to suppress evidence obtained from it. The timing matters because digital evidence preservation and the chain of custody arguments benefit from early intervention. Do not assume that because they took it that you have no remedy. You may have significant remedies, but only if you act quickly. What about biometrics and facial recognition? This is still an evolving area of the law, and courts have generally offered stronger protections to passcodes under the Fifth Amendment than a biometric unlock features like fingerprints and a face unlock, on the theory that a passcode is testimony while a biometrics is more likely a physical key, right? Like you're giving your fingerprint. That does not mean biometric unlock is wide open for police, however. Courts in California have addressed this in different ways, but the safest practice is if you're in a situation where police contact is possible, do not unlock your phone with your face or fingerprint in front of the officers who may be watching, demanding that you do that, and you do not have to comply with a request to press your finger to a device without speaking with an attorney first. The plain view issue. If you're actively looking at your phone when police are present and they can see your screen, anything visible without any search action on their part can arguably be considered as plain view. This is not a reason to panic, but it is a reason not to have sensitive information open on your screen during a police encounter when you're being detained or being questioned. And one more thing, asking for consent is almost always a sign that they do not have a warrant. When a police have a warrant, they typically just say so. When they are asking for permission, it is because they need it. Can I see your phone? Means they're probably not in a position to compel a search right now. That is useful information. Do not hand them what they are asking for when they're not legally entitled to demand it, because you don't know how that's going to be used against you, right? So a clean phone script to commit to memory is step number 1. I do not consent to a search of my phone. Step 2, if they push, I do not consent. I want to speak with an attorney. Step 3, if they take it, do not resist physically. Do not escalate things. Document everything afterwards. Have you ever been asked to hand over or unlock your phone by any police officers? What happened? Drop a comment with your county, and I try to read every comment, and I can tell whether what they did lines up with what actually the law requires them to do. If you want to know your rights when police come to your door, watch my video on that topic right here on this channel. And if the police have already searched your phone in San Jose or anywhere in Santa Clara County, you want to speak with an attorney, you can call our office at Night Law at 408-877-6177. A search without a warrant and without consent can be challenged, but only if you move quickly. What questions do you have about digital privacy and police searches? Drop them in the comments below.